thank you for joining us for this information session. Um, I believe that you wanted to introduce the first topic, Daniel, and that is the essence of what is a will. And in that regard, the general idea of this document is to set out a person's wish as to what's going to happen with his or her estate once he or she passed away. The idea is to um, be able to record those wishes in an enforceable way that whether it's going to be the court or the person that was appointed to look after one's estate, to be able to follow those wishes to the extent possible and to the extent that the law permits. The idea is that this document will be, and the type of documents that we're talking about is uh, the format that requires witnesses and a proper execution of a will, as opposed to another type of holograph will that we're not going to touch on that format. So with respect to the type of will that we're talking about a testator, which is the person who leaves his or her estate to others and be able to outline specifically what is going to happen to his or her assets, liabilities, who should be receiving it, and in what circumstances. Is there anything else you would like to add there, Syed?
Yeah, thank you, Golan. So just to for the audience's understanding, when a person is alive, whatever he owns or he has in his or her bank accounts, it's called assets. But once a person dies, that becomes his estate, which is ESTATE. So what happens is when a will is done, a person actually states what should happen to those as assets, which becomes estate actually after his death, who should have a share in those assets or the estate, and as well as, you know, what should form part of that estate. So one of the things that needs to be considered in this document is what should form part of the estate. So if you have an investment, say a registered retirement savings plan, or if you have an insurance policy, and if you have a beneficiary mentioned in those documents, then that would not form part of your will or part of your estate. So what happens is in that case, you know, the person who you have named as the beneficiary would get, you know, that amount under the RRSP or the insurance policy. Now, if you own a house, suppose you own a house with your husband or your son or your daughter, and it is a joint ownership property, then also if, you know, you die, it would not be part of your estate, but it would go to your the other person who is the joint owner. So all these things are very important to consider while drafting a will. So that is why when people come to us as estate lawyers, we sit with them, we do something called an estate planning, basically meaning what would be forming part of the estate and what would not be forming part of the estate. What are the taxes payable? Because even after a person dies, they actually have to pay, I mean, the estate trustees, who are the people who would manage the properties after the person's death, would have to pay something called estate administration tax. And there is a formula laid down by the government which needs to be paid for properties, which is like houses, you know, all those type of assets. So these are things that needs to be really considered, as well as, you know, if there is a person named in the will who's the person who will be managing the property, whether they will be entitled to any payment after, you know, they have performed their services. So all those things are important discussions that needs to be had with a professional advisor, preferably a lawyer. And then, you know, you can draft your will, and that is when a will becomes effective, and then, you know, it can be enforced the way the person who died wishes. So that was my, you know, further, you know, statements about that.
Thank you, Syed. Can you also talk about other items that can be covered in a will?
Thank you, Daniel. So in terms of the other items that can be covered in a will is that, you know, So if you have like minor children, say children who are less than say 18 years old, you might want, them to have the money or the assets after they turn a certain age. So it can be if they're turning like 23 or 25 or whatever age you think is reasonable, right? So that is something that can be mentioned in the will, in terms of, if there is a trust, or a trust will be created, whether the trustees will be managing the assets or the monies for the children, and they will then give the children the money when they become adults, or up to a certain age, when they attain a certain age. You can also, if you have minor children, name people who would be acting as guardians for your children, because if you or your partner dies, what would happen to the children? Who would, who would take care of them? So the guardians can be mentioned in the will. You can also have plans about, your funeral. How do you want your funeral to be done? If you want to donate your organs, you can mention that. On top of this, of course, as I was mentioning before, that one of the primary things that you have to mention in the will is that who will manage your properties once you die, who will be the estate trustees, or previously we used to call them executors. Basically, they are the persons who executes the wishes of the person dying, and also who will be the beneficiaries, or the person who will be having a share in your assets after your death. Those are usually the things that are other things that are covered in a will. So if you want to add something, Golan, to that.
Yes, Syed, just trying not to repeat some of the topics that you mentioned, but I think that some of the areas that one can cover, and some of them are essentials, would include obviously the actual assets that one wants to give away, the proportion of the sharing of these assets, and some scenarios that perhaps you want to think about if one of the beneficiaries is no longer around to receive and does not survive a, the person, the testator, the person who actually left him the gift. Uh, Other items that could be specifically gifted to beneficiaries, it could include a certain jewelry and photographs or art. All of these things could be made part of your a list of assets to be given away after your death. Um, Other topics that could be covered in the will would include the payments of liabilities, perhaps even forgiveness of debts and the like. But other topics perhaps could be the what should happen in the event that the assets are not able to be divided in the way that you actually wanted. So you kind of you plan some scenarios that may happen at the end of the road if something happens and the real plan for the initial distribution of the assets is not follow through, or because of any reason, maybe the beneficiaries did not survive, maybe something happened to make it an impossibility, and then you can also include these type of scenarios in the will. I think that the type of thing that you can include. You can also look after a situation where you have beneficiaries who are incapable, disabled, and you want to benefit them as by way of creating a trust fund. All of these things have to be carefully looked at and drafted in a way that would give it the effect that one wants. Daniel?
Golan, can you talk about powers of attorney for personal care?
Yes, certainly. So Syed already mentioned the scenario where we're actually using a will, and that is after death. That's where the document takes effect. The other type of documents that is very important, in my view, it's even more important than just having a will, is what happens while you are still alive and you want somebody to help you and assist you um, with maybe personal hygiene. Maybe it's going to be something to do with electing a surgery if necessary. All of these situations can come up because of many reasons. Firstly, I mean, the most a common reason that one would want to use a power of attorney is in the event that he's not capable, he's not able to make decisions. And in this particular question, the question was with respect to personal care. Then we can look at decisions that one can make regarding his personal hygiene, where he's going to be for care, whether it's going to be a home care, whether it's going to be nursing, whether there's going to be a surgery needed, and even the statement regarding your personal feeling regarding heroic measures to the extent that the medical profession can follow. And when I say heroic measure, I'm talking about resuscitation and taking measures to keep you alive with a life support machine, even though that's not your wish. All of these statements and wishes can be set out in these documents. Some Sometimes the a phrase that being used with respect to power of attorney is a living will. The legal term should be and is the power of attorney that you give one to make decision on your behalf with respect to these aspects that's concerning your personal matter. Side, anything else that can be added here?
Yeah, thank you, Golan. Actually, you have very nicely and succinctly described what a power of attorney for personal care is. Just for the audience understanding, I would just want to mention what is the difference between a power of attorney and a will. So, as I said before, as Golan was mentioning as well, that a will actually operates when a person dies, but a power of attorney is a document which is only operative when the person is alive. So through this document, a person who's called a grantor in law actually grants or gives another person power to take decisions on his or her behalf. Now, in terms of a power of attorney for personal care, the other one is actually the power of attorney for property. So we're going to talk about the power of attorney for personal care now. In this document, actually, the person actually allows another person to take health-related decisions. So as Golan was saying, can be hygiene, it can be where the person, if they are incapable of taking care of themselves, which nursing home they will go to, and as well as as Golan was mentioning, if there is a situation where the person is not in a position where they cannot, the doctors determine that they will not be able to survive, whether the personal care attorney can decide that they should be allowed to die. The other things that actually, on top of what Golan said, can be inserted in a power of attorney for personal care is the compensation or the payment to be made to those attorneys for their services. In the power of attorney for personal care, I have seen situations where people also want their wishes to be like how my funeral will be done, or whether there will be any organ donation or anything of that nature as well. And one of the things that is also very important in a power of attorney for personal care is when it will be effective. When will this be actually enforced? So there can be two situations where you can mention that it will be only effective or enforced when I'm incapacitated or I'm not being able to take decisions. If that is the case, then in order for the attorney to actually act on that document, they have to do a capacity assessment or have to prove to the hospital or the authorities that this person is actually incapable of taking decisions. It can also be that the power of attorney for personal care can be written that it will be effective immediately. In that case, the attorneys actually have authority to use that document whenever the situation arises, and they don't have to wait for any capacity assessment being done. So in our firm, what we usually do is we do it in a way so that the document is effective immediately, and we give it to the person who is giving the document, the grantor actually, and then they probably keep a document and then give one to the attorneys that they have nominated, and then they can act on that when as and when it is required. So those were some of the things that power of attorney for personal care covers.
So, can you talk now about powers of attorney for property?
Thank you. Yes, of course. So basically, in terms of the power of attorney for property, unlike the power of attorney for personal care, which actually takes care of or allows a person to decide about a person's health care, a power of attorney for property is a document which allows a person to nominate another person or to appoint another person to take decisions about their property. So this can be property which includes, bank accounts, it can be assets, and those type of property related matters. So in terms of these documents, the attorney is authorized actually to take this document and use it and go to the bank and operate the accounts on behalf of the grantor or the person who's giving the authority. This document also have situations where it can mention when this document will be effective. It can be effective immediately, or it can be effective on the incapacity or illness of the person when the person is unable to take decisions. Now, in terms of the power of attorney for property, what we always suggest is that there should be a balance. So we always suggest or prefer that there should be two attorneys, so that the property is handled properly and in good faith by the persons who are named in the document. And if it is mentioned that it will be effective immediately, then we usually at our firm, what we do is we keep the original document, and then when the situation arises, the attorney can come to us, and then we actually satisfy ourselves whether our client is in a situation where there's need for this document to be enforced. And after doing the necessary inquiries, we then hand over the document to the attorney. And there are some other provisions in terms of compensation and other usual clauses there. So you can probably add some more to that, Golan.
Yeah, so perhaps the a main idea of a document that looks after your property while you're still alive is that one can do everything that you can do. So you give the powers to somebody else to do things that you can do other than making a will. But that may include transfer of money, payments of debt, all these sort of things that you will do in the usual course of things, and that sometimes the situation arises that you're not able to do that because of different reasons. You may be out of the province, you may be out of the country, you may be sick, you may got into an accident that you're not able to look after these matters. And the most important one is when you are not having a capacity, the ability to actually make this kind of decision and make the proper actions with respect to your properties. And property may mean even selling your car or selling your house or selling your condo. All of these things are part of what is a power of attorney and the limitation that can be put on the document with respect to when you want that document to be released to the person that you wish to take care of these things. The idea is that you have the control of the circumstances as to when do you want a person to step into your shoes in a sense and be able to act on your behalf. And all of these things can be drafted very clearly and carefully in the document of a power of attorney. A power of attorney can also be just limited to a certain type of property and not others. So that can also be part of the limitations that you can set out in the document of the power of attorney. And in terms of appointing the person to look after your assets and property, as Syed mentioned, you can have it by way of having more than one person look after that. So there's a little bit of more checks and balances in the idea of who's going to look after things and how decisions are being made. This is in general what can be expected from a power of attorney for property as well.
So one of the things I just wanted to add, Daniel, is that in terms of a power of attorney document, you can anytime cancel the document. So if you want, okay, I've done with a particular objective of, appointing somebody to do certain tasks, say Golan was saying, selling a car or selling a house, then after that, particular incident is over, you can cancel that document. So as well as a will, actually, you can actually amend or make a new will anytime you want. So it's not that you make a document and it's there forever. Of course, it will operate until you're alive when it's a document for power of attorney, and the will will be effective after you die unless you amend it before you die.
All
Thanks,
of this, of
Syed.
course, assuming that one still have is of sound mind.
Yes, of course. Yes, thanks, Golan.
Golan, can you talk to us about proper signing of the documents and the impact that COVID-19 has had on this process?
Yes, I'll be pleased to do that. The form, as I mentioned at the beginning, the format of the will and power of attorney that we're speaking about is the version that requires a witnessing of the person who granting the wishes and the powers to act on his behalf if we're talking about a power of attorney. So the idea is that um, there are formalities that need to be followed to the T in order for the document to be valid and enforceable. A, one of these requirements required a certain witnesses to be present, physically present, when the person who executes the will is doing so. The idea was that two witnesses would be present physically with the testator. The testator is the person who's actually putting the documents and setting out the wishes as to how the estate is going to be distributed following his death or her death. The COVID-19 situation has caused some problems, let's say, in terms of keeping a safe distance, the need for social distancing, the need to avoid a contagious situation with the people who may carry the virus and so on. The Law Society and the Attorney General have relaxed the rule during this crisis to allow for virtual signing. That means that people would be able to have a will done even in a video conferencing situation, just like we are in a situation like now, but in a fashion that we can actually see each other. And all of this is with additional safeguards that need to be looked after when a document is being executed virtually. One of the main restrictions is that one of the witnesses has to be a lawyer when the executor is signing the document. Anything else to add, Syed?
Yeah, so as Golan was saying that in terms of this COVID-19 situation, a lot of people are dying in Ontario as well as in other provinces in Canada. So the government actually has relaxed the rules. And as Golan was saying that, you can do virtual signing. But what we have seen and what other lawyers who are, practicing estates have seen is that, it has become a bit cumbersome in terms of, there should be documents which has to be signed by the person. The same document has to be witnessed by the other two witnesses. So there are two ways this can be done. One is where the person who is the testator, as Golan was mentioning, the person who's making the will would be signing it in a camera in front of the other people in their visual in the Zoom or any type of those type of Skype video conferencing. And then that document can be sent to the witnesses. And then when the witness is actually signing, the other person will also be seeing that, because it says in the presence of. So all three people will have to be together 3 times actually when the other witnesses are signing. And on top of that, when you do a will, you have to do another document which is called an affidavit of execution of will. So this is a document which confirms that, one of the witnesses will confirm that, okay, this person who is the person making the will actually signed the will in my presence. And then another commission or another lawyer would confirm that, yes, this is a sworn statement and he has made this statement, the witness in my presence or in front of me. So all these are extra steps that needs to be taken. Of course, pre-COVID-19, a client would have come to us and they would have signed the document in front of 2 witnesses, and we did the affidavit of execution at the same time. But now you have extra layers involved in that situation. Now, the other question or the other way that will can be done is through a holograph will. A holograph will is a document which actually is signed by a person in his or her own handwriting, and he can state what his wishes are. So that is another way of doing a will. But if there are a lot of assets, a lot of things involved, so we always suggest that professional advice should be taken, and a lawyer should be allowed or be given the opportunity to draft a will, review it with the client, and then the client signs it. um, one of the things that I would also like to mention, and that we are in a situation which has never, we have never seen this before, and maybe our parents or grandparents have not also come across this situation in their lifetime. We don't know how these wills, this COVID-19 wills would be interpreted by a judge. So those are things that we have to wait for, and then when there will be judicial pronouncements or cases that deals with the formalities that needs to be followed, then only we will know how these are tested in a court of law. Because at the end of the day, everybody wants to make a document or a will or a power of attorney which will be enforceable when the time comes and when it is needed. Yeah, thank you, Daniel.
Thanks, Gulen. We're not going to proceed to answer any questions that you have. If you've not sent me your questions yet, it's not too late. You can use the chat option on your screen, type in any questions that you have and send them to me, and I'll make sure to read them out to our speakers. First question we have is, are the courts processing any applications these days?
So I can just answer that question. So what happened is, I actually did a probate application last week, and first of all, what I saw in the notices to the profession is that the courts are only hearing urgent matters now. So in the situation that I was in, was that the person, the person who made the will and who has died actually in April, he was providing for these people, and a number of these people, like 3 of them, have been unemployed. So I had to do a letter to the judge, to the court, actually, to the state's court, saying that, okay, this is the situation, this is the urgency. Out of these beneficiaries, these people have already been unemployed. They are in a financial and dire situation. So they urgently need this will to be probated so that, they can access the funds for their survival. So I did a letter, and then I attached it to the application. And once I sent it, I was surprised to see that within 2 days, the certificate was issued. And this was in Brampton Court. So in terms of the other courts, I know each court has their own ways of dealing with it. I know Toronto is dealing with probate applications as well. From my friends who are practicing there, I know they have said that they have done probate applications. I know that Newmarket is also doing. So yes, probate applications are being processed. However, as I said, since the courts are now only hearing urgent matters, they will probably want you to show some sort of urgency as to why it needs to be done immediately on an urgent basis.
Perhaps
Daniel?
just to clarify for the audience, the use of the term probate, um, the meaning is that one needs to sometime approach the court to be appointed as the estate trustee pursuant to the will if one was made. And a situation like that, we're still using an old term that's called probate of a will. And like Syed said, it's currently in the situation that only urgent matters are being looked after by the courts. And it requires a certain specific procedure, convincing the court staff first, and then the judge, that the matter does in fact require immediate attention to assist the potential beneficiaries of the estate. Daniel, anything else for us?
Next question we have is, why do wills cost so much money? Because there are people who think that wills are a simple document, just a couple of pages of paper saying where things should go. So can you guys just talk about that?
If I may, Daniel, I can pick up on that question. It's firstly, it's a relative term, whether the cost is high or low. The idea is, as we spoke about it earlier, some of the topics could be very complex, and some of the topics may be fairly simple. That's the reason that the cost of preparation of these documents varies depending on the complexity. Um, it could start with a few $100s of a package for a will and a power of attorney. It could be much more expensive than that if a certain trust funds have to be established and other estate planning has to be accomplished within the document of the the will. So that's the reason that the cost varies, first of all, and secondly, there are formalities that you don't want to overlook. And the idea of having a lawyer involved in the process is, in my view, essential, because you don't want to do something that ends up being not enforceable, and eventually all that you were trying to save is actually costing much more to the beneficiaries, whether it's in terms of taxes and other situations that could have been avoided with the proper drafting of the document.
Yeah, I would
Daniel?
also like to add, Golan, to what we are saying is that, when we talk about wills, we're not just drafting a document, we are talking about estate planning. So as we discussed before that, it needs to be understood what will form part of my estate, how much taxes would be paid, um, what will happen to the joint properties, how should properties be, owned, in terms of, the probate or the, estate management purposes. So all these things needs a thorough discussion. How would the investments, be taken out of the state or would be forming part of the state? So these discussions would actually have at least an hours, time for a professional, and then only, you can talk to the client about, the beneficiaries, the estate trustees, and all the other provisions that we have mentioned. So once everything is done, we draft a document, we send it back to the client reviews it, and then we can only, confirm, okay, these are the wishes, and, that is how the document is drafted. So it's not like just getting some precedent out of, or a format of a document from the internet and then filling it in. And because the courts are very, very, careful about, probating, as we were saying before, of a will, because they need to make sure that, this was what the person wanted and all the names have been properly spelled out, everything is in proper order, and there is no question mark about it, and then only they issue the certificate. So yeah, that needs some time to discuss, and then, that's why, and it's not that expensive, to be very honest, when you think about other areas of law, when you engage lawyers and, spend amounts on court litigation or other purposes. Yes.
Thank you, guys. Next question that we have is it true if someone does not have a will, the law would give everything to their wife and their children? And if that's true, then why does someone need a will?
So if I can just answer that question, if you don't have a will in Ontario, then there is a law called a Succession Law Reform Act, which basically says what will happen to a person's properties or assets or bank accounts if the person dies. So what happens is, if a person does not have a will, the wife or the spouse or the husband, whoever is surviving, would get a preferential share, basically meaning $200,000 from the state, or the assets that the person leaves after his death, and the remaining amount is shared with their children. So there are some specific categories mentioned that, who would get in whose place, and, the first person who will get is the wife, the preferential share, or the husband, the preferential share, and then the remaining amount. So suppose there is wife and one son or one daughter, then after the $200,000, the wife will, or the husband will share half of it, and the remaining half would go to the son or the daughter. If there are three of them, then the wife will get 1/3, and then the 2/3 will go to the remaining children. So there are different categories mentioned in the Succession Law Reform Act.
Perhaps the idea, I think the question was actually, why should one have a will if that would happen, and the law is already looked after the situation when one does not have a will. I think that what have to be borne in mind is that the Succession Law Reform Act, the legislation that is in place, does not look after all the scenarios that one wants to consider, whether it has to do with setting a trust funds for the kids, whether it's the release of the property after a certain age and not necessarily at age of majority, other aspects of maybe specific items that you want to leave to certain beneficiaries, whether it's a niece, a daughter, or a friend, or even a favorite charity. All of these things are not being looked after by the legislation. The legislation is very broad and not necessarily what you want to achieve at the end of the day. It's unfortunately it's a default situation when one does not have a will, but that's the reason that to control your assets, to control how things are going to end up and in whose hands, it's you're better off having it detailed, set out properly in a format that would be enforceable and that can be followed, so your wishes are satisfied completely.
The next question we have is, if someone wants to give their paintings to their grandchildren, can they just can they just tape the names of their grandchildren to the back of the paintings?
If I may, I can just pick up from what I just mentioned earlier about a giving somebody a specific bequest, a specific gift that you want to leave with someone, whether it's going to be your child or your friend or your neighbor. The idea of just putting a name on an object does not do the trick. The idea is that firstly things can change and a dispute may arise after all. The one thing that should be done is setting out those specific bequests, specific items that you want to leave to somebody in your will. That would be making sure that that specific items with the description, perhaps with the photographs attached, and having it stored in the right place, would ensure that that item in fact exists when you pass away, and the item is available to be transferred to the person that you wanted to. So the short answer is it's not a good idea to simply tag a name to an object or to the items and hope that it would end up in the hands of that person, because many things may arise a subsequent to that.
Yeah, so just to add to what Golan was saying, one of the obligations of the estate trustees or the people who will be managing the estate is to follow the wishes of the testator or the person who is making the will. So once it is part of the will, they have to give it to that person. So if you tape something, you know, at the back of a painting or whatever, that's not a document that would be, or that's not something that will be enforceable or binding on them. And there are beneficiaries or people who have been named in the will or any other document. They might not agree to that type of, you know, wishes of the person who died, right? So it's always better to have, as Golan was mentioning, in the will, specifically mentioning with the details, that there's descriptions if necessary, with photographs, so that there is no confusion as to who would be getting what.
The next question we have is, can a power of attorney for property and a power of attorney for personal care be put onto one document?
So in legal terms, there is no bar in having a power of attorney for property or the power of attorney for personal care in the same document. But what we do in our practice in our law firm is that we usually do it in two separate documents. One of the reasons that we do that is that, you know, the power of attorney for personal care is usually required if you go to a hospital or a nursing home, or, you know, in an emergency situation where, you know, some healthcare decisions needs to be taken. So if it is different powers of attorneys that is mentioned in the two types of documents, there is no need or necessity for those authorities to know who would be the other attorneys, right? So but even where there is the same attorney that is mentioned, we I mean suggest that, you know, it is better to have two separate documents, so that, you know, there is no uh, uh, question of, you know, the authority knowing who is managing the assets, or the bank or the other authorities knowing that who would be taking decisions about the personal care. So it is advisable to have two separate documents so that we can use each document as and when the need arises and to the relevant authorities. Goran, you want to add something to that?
Also, just the quick answer to that is it's possible, but you really want to keep them separate just so that only the relevant a category or the relevant person will have the power of attorney, whether it's the doctor, the nurse, or the bank, if it's a matter that's concerning a property. The banker is certainly not interested in knowing what's going on in terms of the personal care, and perhaps vice versa with the nursing home and the power of attorney for property, especially, of course, if the attorneys are different. That's obviously would require separate documents. Daniel?
Next question we have is, if someone has a living will, when they die, will the living will take over and describe how things are to be distributed?
So if I can pick up on that, because that was already mentioned earlier in terms of the applicability. When is the document apply? And Said mentioned that it's only during your lifetime that the so-called living will, which is the power of attorney that sets out how you want things to happen during your lifetime, are effective. Once a person passes away, the document dies with him. So the answer is that the power of attorney or the living will is not effective once the person dies, and this is where one would be looking into a will that has been prepared, hopefully by the same grantor or the deceased person. Um, Hopefully, had done so earlier and was looking after the distribution of his estate and his wishes in that document. Daniel?
Sayed, do you have anything to add?
Yeah, I just wanted to add that, from the person who made the question, is that, whether the power of attorney would operate after the death, as Golan was mentioning, and I said before that, and the law is very clear on that issue, that, a power of attorney dies with the person, because it is only an authority given on behalf of a person. So if that person is not alive, so how can that other person who has been given the authority actually act on that authority? Now, one of the things that a person can do, if he really wants things to be distributed, they can do a gift when they're alive, actually. So they can just give something, when they're alive, so that there is no question of whether my wishes will be, executed after I die. And if they really want it to happen after they die, then as Golan was mentioning, they have to do a will, proper will.
Thanks. The next question I have is, one sibling is the power of attorney for the father. The father is in long-term care facility. The sibling looks after the cottage and the father. The father says that the cottage will go to that sibling for looking after it. And this cottage is continually being renovated and improved with the father's money. Is there something that can be done in a situation like this?
I can pick that up, Side, if you want.
No, that's
Uh,
okay.
so, with respect to the set of circumstances, it sounds like there is a power of attorney that was given to one sibling to look after the property of the grantor, the person who actually gives him that authority and owns the cottage. So, in general terms, we are in the area of power of attorney, and that it brings us to perhaps a topic that we haven't spoken about yet, and that is the duties of power of attorney or trustees when it comes to a will. So the idea is that one is not simply able to do whatever he wants to do, regardless of potential beneficiaries or the wishes of the grantor, the person who gave him that authority. There is a way to compel that person to provide information and details of where the money goes and the transaction that's happening. But with respect to that specific set of scenario, I would suggest that that would be looked at carefully, separately, and that could be perhaps looked at by a lawyer to review the circumstances in a better way. But generally speaking, there is obligation on estate trustees on power of attorney to pass accounts And that could be either by way of an agreement or by way of auditing, or by enforcing it by a court application. So all of these have to be looked after and be considered when one is taking on the role of an estate trustee or power of attorney.
Syed, do you have anything to add?
Yeah, just to add to what Golan was saying, and just to reiterate what he was saying, to be very honest, is that a power of attorney or an attorney actually is in a fiduciary relationship. So it's of utmost good faith that they will actually exercise the powers on behalf of the grantor or the person who has made the document as per his or her wishes and in his or her best interests and in good faith. So if a person thinks that, okay, I have now authority to all the bank accounts and I'm just going to use that for my own advantage, and I know that this property is probably coming to me or something like that, that is not going to be allowed in a court of law, and the law does not allow it. So as Golan was mentioning, the other people who are beneficiaries can ask for passing of accounts, and then that person would have to respond to a court as to how he or she managed the estate or the properties when there's a power of attorney. So all these things are very important. So a lot of people don't actually understand the huge obligation that this entails basically when you are a state trustee or you are an attorney, because we always suggest that these people who are actually acting for other persons should have all the receipts, all the documents, should have everything documented, so that there is no question about whether they did anything outside of the best interest or not in good faith when they're performing their duties.
Thank you, guys. Those are all the questions that we had. So let me just put this up. If you guys have any more questions, a consultation can be arranged to evaluate your specific situation or circumstances. You can contact us using the information that's on the screen now. As mentioned in the beginning, this was a general information session. Nothing mentioned should be taken as legal advice. Next week, we will be hosting another information session on a related topic on losing a loved one and managing the estate, and be sure to look out for that invitation. That concludes today's session. I want to thank everyone for attending, and I hope you're able to join us next time.
Thank you, Daniel.
And thank you, Syed. Thank you for everybody who was joining us today. And
Thank
we look
you.
forward to talking to you again next week.